now move on to the Law Prize, which is going to be presented by Amir Licht and Roberto Bonsignore from Cleary Gottlieb. Amir.
Thank you, Marco, and also thanks to Roberto and Franklin for the engaging first part of this event. I would also like to thank my colleagues at the editorial board of the ECGI Working Paper and Law series. These are Horst Edenmüller, Martin Gelter, Geneviève Welleringer, Curtis Milhout, and Iris Chu, for together with me shouldering the selection process of the winning paper, and also, of course, to Elaine McPartland for seeing that we actually do that. So I'm delighted to introduce Dionysia and Katelouzou from King's College in London and Mathias Siems from the European University Institute as the winners of the Cleary Gottlieb Hamilton Steen Prize for the best ECGI working paper in law for 2020 for the paper, The Global Diffusion of Stewardship Codes. We live in a period in which many people look to institutional investors as the source of, I would say, humanity's last hope. So institutional investors are expected to mitigate and in some way discriminatory practices, environmental harms, other bad behaviors in their portfolio companies, and ultimately to save our planet from reaching boiling point. Stewardship codes are supposed to guide institutional investors in their way to achieving these important goals. And in their prize-winning paper, Dionysia and Mathias examined the diffusion of the content of stewardship codes in a period of over nearly 30 years. Not for the first time, the UK emerges as the source of much inspiration for other codes around the world. Codes in many countries, they show, have drawn heavily, as we say, on the UK source and on a couple of other sources, not unlike what our students do quite regularly, I must admit. Dionysia and Mathias go on to analyze the implications of this trend, their empirical work, and their analysis make for a great read. I strongly recommend it. This has made their paper the winner of the Cleary Gottlieb Hamilton and Steen Law Prize for 2020. Congratulations, you two. And I will now turn the floor to my friend, Roberto Bonsignore from Cleary Gottlieb, to say a few words on their behalf. Roberto.
Thank you, Amir. It's always a pleasure to sponsor this prize and a true honor. And I thank you, of course, the Institute and you, Amir, and all your team and Elaine for supporting and sponsoring research, which is always of the highest quality level. And Dionysia's and Mathias' paper is no exception. It is a fascinating subject, not surprisingly at the forefront of what's going on in the corporate world and in capital markets across the globe today. In terms of substance, it's an absolutely fascinating subject, but also in terms of methodologies, I must say, it's a really fascinating read, and I also highly recommend reading it. It's a very interesting methodology, very thorough and rigorous, and quite interesting approach that the authors have taken to a very complicated matter, and it is also quite interesting to see how through that methodology you really get an X-ray analysis of what's going on across the globe in this field, and how models have circulated across legal families and clusters, and see the relationship of what's going on across the world. And I think it was a really fascinating read. So congratulations to the authors for such a high quality level of research and work. And again, congratulations to the Institute for supporting this research. We're, as I said, delighted and honored to be sponsoring this type of work.
It is a great honor for us to be here today. And I would like to thank the ECGI, but also Amir and Roberto for their really kind words. Winning this prize is fantastic and so motivating, not only for Mathias and myself, but also for everybody involved in the broader project on global shareholder stewardship. So the paper that won the prize is part of a large project on global shareholder stewardship that brings together more than 100 academic and non-academic members from around the world. And the project was put together by Dan Pachniak and myself back in 2019, when the term stewardship was at a very embryonic stage. Since then, we organized the first global shareholder stewardship conference, a book coming out from Cambridge University Press with 33 chapters, and there have been all series of events. So the paper with Mathias, the one that won the prize, is part of this project and is going to be part of this book. So let me give you over and some of the things. The paper, as our title explained, is about diffusion of stewardship norms across countries. The last 10 years or so, stewardship was understood as monitoring within invested companies. And it's that understanding that traveled a lot around the world through the means of stewardship codes. And this diffusion of stewardship norms that we examined in the paper is part of a wider trend of one-way transfer of corporate law and corporate governance that we have seen before. For instance, we have seen that before in terms of corporate governance codes. So now the trigger for writing this paper was that, and I'm not sure how many of you know that story, but back in 2019, when we put together this project, there was a widespread belief among policymakers, but also among many investors, especially outside the UK, that the world has adopted codes ostensibly modeled after the 2012 version of the UK Stewardship Code. And this was the trigger and what made us, Mathias and myself, to try to systematically examine this diffusion hypothesis. This hypothesis that all stewardship codes are ostensibly based on the 2012 version of the UK code. And to test this hypothesis, we collected textual information from 41 codes across 20 different jurisdictions enacted between 1991 and 2019. And we systematically examined those using content analysis. But before we look at some of the findings, let me first establish a working definition of what a stewardship code is. So the way that we define a stewardship code is the following. A stewardship code is a non-binding set of principles, standards, or best practices, which is directed to institutional investors, so asset owners or asset managers, and by extension to service providers, or in some cases, the lawmaker. And those codes are issued by public or private bodies, so by stock exchanges, and the codes relate to the oversight role of institutional investors. And the aim is to create long-term value for clients and beneficiaries, but also more recently to promote corporate sustainability. And what is interesting is that the codes have what we can describe as corporate governance aspects. So they relate to things like, voting, shareholder monitoring, engagement, but they also have investment management aspects. So the codes are about conflicts of interest, reporting duties to beneficiaries, etc. And because of our definition, we excluded the Singapore Stewardship Principles for family businesses, because this code is designed to focus on non-institutional controlling shareholders as the primary steward, whereas we focus on institutional investors as stewards. So if you look at the next figure, you can see the evolution. And here we distinguish between preliminary initiatives and stewardship codes in the narrow sense. So a preliminary initiative is defined as to the shareholder role of institutional investors, but is somehow limited, either in scope, for instance, it's only about asset owners, pension funds, or asset managers, or maybe in content, for instance, it can be only about voting rights, as for example, the Swiss code, or maybe the drafting style. So it can be more like a policy statement, as the early codes before 2009. And this distinction is very useful when you have a single country with more codes, like for instance, the UK or the Netherlands or in Canada, because those countries adopted a code after implementing what can be termed as a preliminary initiative. But there are also other countries like India or Switzerland, for instance, or even the US, that they don't really have a code. They only have what we define a preliminary initiative. So if you look at the figure, you can see that the forerunner here is clearly the UK. And you can see that before 2009, actually in the UK, there were 4 different stewardship codes, mostly in the form of preliminary initiatives. And then between 2010 and 2015, you can see that 8 countries addressed shareholder stewardship through the adoption of a code. And then the period between 2016 and 2017 marks a spike in the evolution of stewardship codes, with 11 more jurisdictions adopting a code. It is also noteworthy that the figure stops at 2019, but 2 more codes were published in 2020. And these are both revisions. One
Dionysia?
And the other in
Dionysia, I apologize for interrupting, but we hear you. Audio quality is a bit bad.
But
maybe
for
you would
this
like
paper,
to turn off the camera.
We consider so yes, Amir.
Audio quality is a bit bad.
Yeah,
this
I can
point.
do that.
Maybe you
sure.
just turn off the camera.
Let me find the way though. Now it should be fine. It wasn't so easy to find the button. So as you can see from the table, we consider 41 codes published up to the end of 2019. And most of the codes, as you can see, relate to specific countries, but we also have some transnational codes like the ICGN code and the EFAMA code. So we include both jurisdictional, but also interjurisdictional codes. And you can see here that the table also contains information about the issuer. As I mentioned, some codes are published by public bodies like stock exchanges or committees organized by them, whereas other ones are published by private issuers like institutional investor associations or other investor-related groups. And we also take into account the language and whether the code is available in other language, because we focus on diffusion, it is possible that such codes may use different words than the ones that those codes that are only written and published in English. So here I hand over to Mathias.
Okay, then good afternoon also from my side. So I think we need the next slide. So Dionysia, can you? Yeah, okay, click. Thanks a lot. So first I want to say a few words on the concept and method of then our paper and what we then find. And one is that we kind of, what Dionysia explained, we put this kind of context of like how the codes evolve in the discussion about legal transplants, which is a discussion in comparative law, and then also the discussion about policy diffusion, which is more like a discussion, I guess, in political science and in international relations. And that's kind of our conceptual framing. And it also ties in with some prior research, for instance, on the diffusion of corporate governance codes. So we mentioned here a paper by Gerner Boyle, where he looked at corporate governance codes. But we would say we're the first paper here that we actually apply these kind of concepts to stewardship codes. We should also clarify that we look at formal diffusion. So we look then, as you will see in a second, at the text of the codes. So we don't claim that all these codes function similarly across the world. So we look at the wording and how the wording of these codes has possibly influenced each other, and in particular, considering the UK as a model, as I guess we already mentioned now. The method we apply is sometimes called content analysis, which can be defined as a way to analyze the informational contents of textual data employing tools that are objective, systematic, and quantitative. It's obviously not a new method, and it's not even new only in law, but it's still fairly underexplored, we would argue. And in particular, we think we are the first paper that applies it to these stewardship codes. But that's in a nutshell on the concept and the method. So now let's get to the main findings, and also now continuing with also the explanations on the methods we apply. So essentially the paper has two main parts. So the first one is that we look at general evidence of diffusion between these codes. And there essentially, and Amir Licht mentioned it in the summary, we apply tools where the drafters of the codes have copy-pasted, like students perhaps, text of these codes, and that may indicate some kind of formal diffusion between these kind of codes across time. We are the first ones who would do it with these codes, but there is some previous work on that has applied similar methods. So we cite here a paper by Elliot Asik, who looked at preferential trade agreements and found that 90% of these agreements are essentially copy-pasted. As you will see in the next slide, so what we find is less copy-pasting, but we do find some interesting patterns. In the terms of procedure, we use a software called wcopyfind. And then we decided as a starting point that we looked for 4-word strings, how for patterns of 4 words are similar or identical, actually, not only similar across these codes. And that's an illustration from this method, applying it to the Malaysian code and the UK code 2012. And obviously, based on the expectation that we would expect that the UK code had an influence on the Malaysian code. By way of clarification, we should also say that we not only applied the 4-word limitation, but also we checked for instance, 6-word strings, because 4-word strings can also lead to false positives. And therefore, in order to balance false positives and false negatives, we tried different strings, but more or less the results remained unchanged. But that's a natural caveat that there can be also certain words that are just together by coincidence. But that's in a nutshell our method. So now getting to the results. So first of all, we can rank then the codes in terms of similarities. And that's kind of here the top 10 rank. Obviously, one could go further, but it's, I guess, illustrative of some of our findings already. Namely, that we can see that some of the older codes, so that's in the first column, are really the UK code. So we can see that the UK has been influential on other codes, but not only actually the 2012 code, so the big one, but also even the previous one. So the 2001 like previous statement on shareholder stewardship was influential on the Canadian one, and then also the 2009 one actually as well. Interestingly, if we look at the codes that were influenced by the UK code, we can see it's not only the common law codes, so the codes of common law countries like Malaysia or Canada or Hong Kong, but also, for instance, the e-pharma code. So the top #1 rank is actually that this kind of code by the European Fund and Asset Management Association was heavily influenced by the UK code. We can also see some further patterns, which we also will explain perhaps in the next minutes. For instance, the international code by ICJN influenced the Kenyan code, which is perhaps also interesting that like Kenya as a country also not only looked at the UK, but also this kind of international soft law. And also some influence between Korea and Japan, which is perhaps intuitive, at least if we think about countries in the same region and as well with a similar conceptual framework of law. So that's kind of this top 10 ranking. And then looking at all codes, we can present it as a network. That's in the network of all the codes we analyzed. And we can see we colored them a little bit as well, that, for instance, the UK is at the center. Then also the e-pharma codes are fairly central. At the bottom, since I'm currently in Italy, Italy is influenced by the e-pharma code. So that's also interesting, perhaps, that they've been influential in particular in Italy. Going further up, we can see like then India, some common law countries closely connected to the UK, then also Korea, Japan. Interestingly, perhaps, the UK 2020 code, I think Dionysia, if her internet allows it, will mention it at the very end as well, is actually an isolate. So the new 2020 code is actually now quite different from the previous ones. And we can also see in the left-hand side the other isolates, for instance, the 2 Australian codes. They're also different from actually the UK model. So it's also not a simple story that like the UK influenced everything. And obviously intuitively one would have expected that Australia perhaps would have been influenced by the UK code, but that hasn't been the case. But that's kind of this kind of descriptive presentation, first of all, as a network, showing all the codes where there's an overlap of more than 6%, so as you could see in the heading of this figure. So that's obviously the subjective decision one needs to make as one displays these kind of informations in a network. A further way of presenting this information is to as well take the same matrix of all these codes and ask then our program, which is UCNet, which we used to identify hierarchical clusters of these codes. And more or less, obviously, this chart now shows the same findings, which is exactly how it should be because it's the same data, but also with some kind of, I think, further illustrations, for instance, which codes are similar or different. So in the kind of center, you can see we have a couple of common law countries, so UK, India, Malaysia, Hong Kong, Singapore. So they are obviously connected, so there are codes that are fairly similar. We also see here the Pharma Italy link, so there's an overlap of 10%. We see the ICGN Kenya link, and we also see at the top, for instance, Taiwan, Australia, not being very closely connected to the other codes. We do it, and that's perhaps the final point here to make, on the basis, just to repeat it, at the formal similarity of the text of these codes as published in English. Also, in this regard, to clarify, for instance, the Taiwan code was obviously published in English, but also published in Chinese, and same the Korean code or the Japanese code. So there can be obviously as well issues of translation, for instance, if certain codes have not been initially drafted in English. But I guess one could argue also that perhaps since these codes are addressed at international investors, I guess there was presumably a co-drafting of the different language versions. So that's perhaps why it's not a coincidence that we see also some of the codes of non-English speaking countries being closely connected to actually the other codes. So for instance, Kenya, and Kenya is a common law country, so that was wrong now, but even like Japan and Korea are not that different from, for instance, the UK codes as well. But that's therefore, that was now the first kind of method we apply there, namely on the kind of general mapping, more or less in a nutshell, whether codes have been plagiarized in terms of copy pasting certain phrases, certain strings of words. And now in the second part, then the aim was actually that Dionysia will continue, would be that we now zoom in really in the UK as a possible exporter of stewardship, and there we applied then a slightly different method. Perhaps we can give it a try whether Dionysia's internet works, but otherwise I guess I may continue. But
okay, hello. I changed my internet settings, so hopefully you can hear me, and I turned off the camera, so things will be hopefully a bit better. So as Mathias explained, so far we have focused on the language of these codes, but the question now is whether the UK has indeed played the role of a stewardship norm exporter. So to test that, and to test the impact of the UK 2012 code on the text of the other codes, we use a set of words that can be described as good markers for each of the 7 principles of this code, and then count how often these words are mentioned in each of the other 40 codes. So you can see those words here, right? Those 7 words, and each of those words is like a marker for the principle. So for instance, the word disclose is like a marker for principle 1 of the UK 2012 code. So then the next step was to calculate the frequencies and to calculate the relative frequencies of those 7 words across all the other codes. So to be able to do that, we pre-processed all codes following standard practice in textual analysis and textual linguistics. So to give you some examples, we removed all stop words, we decomposed all the words in the roots. For instance, disclosure and disclosing were collapsed to the same kind of word, disclose for frequency counting. We also transformed all words to lowercase, we removed numbers, etc. So in other words, we cleaned the texts. So we are able to apply content analysis. So the figure here presents the relative frequencies of those 7 markers in a chronological order. If you look at the UK code here, you can see that the most common marker word is the word vote, and this is followed by disclose, while the least common one is escal, which is for escalation or escalating or escalated, right? So that's the word marker. Of course, and the same pattern, the word vote, is also the most common word marker across all the codes. So to some extent, those differences may reflect that some words are of more general nature, while some other words are more specific ones, yet we find evidence that these differences are actually, they do actually reflect differences in substance. And just to give you another example, for instance, if you look at the word marker disclose, you can see, for instance, that earlier codes do not really mention the word disclose. Here, for instance, if you focus here, you can see that earlier codes do not focus on the word disclose so much, whereas later codes, they do put a lot of emphasis on disclosure obligations. And on the other hand, earlier codes, they do focus a lot on reporting, whereas the latest codes, they do put a lot more emphasis on public disclosure rather than private reporting. Another interesting finding is that monitoring is an essential part, and every single code mentions the word monitor at least once, but yet there are some differences across the codes. And another interesting finding is that the word marker for escalation is the least frequent word across all the codes. And actually 17 codes, including the EFAMA code, the Italian codes, the 2 Japanese codes, but also the Korean and Malaysian codes, make no reference at all to the word escalation. And this is perhaps due to the way escalation is perceived by different local markets, and the fact that some codes, for instance, the Japanese one, emphasizes a bit more on constructive engagement and adopts a general language when it focuses on stewardship. Interestingly, collect, which is the word marker for principle 5, is also not well perceived across different codes. And 17 codes, including, for instance, the Canadian ones, they do not really mention collective action at all. Whereas, for instance, other codes like the Italian one, they do mention collect 13 times. So there is a lot of emphasis on shareholder collective action in the Italian context, perhaps because of the strategic role of Associazioni, which is the issuer of the Italian code. So then the next step was to test whether these patterns, these different patterns in terms of frequencies, can be explained on the basis of different characteristics of the codes. And here we take into account the nature of the drafter. So for instance, public versus private drafters, the nature of the code, if it is a preliminary initiative or a code, a proper code, the enforcement mode. Some codes are entirely non-binding, some others follow the comply or explain approach, or they have some other mandatory elements like the Indian codes for insurers, and whether or not the code is available in another language. For those codes that are jurisdiction specific, we also take into account the legal family and whether or not the country has one or more cities that feature in the top 20 global financial centers. And the assumption here is that this can be a proxy for the pressure that institutional investors may have exercised to shape the content of the code. So to determine if there is any difference, we calculated the t-test statistics for all these 6 explanatory variables. And as you can see from the table, none of the 6 variables can explain differences across the codes in the use of the words collect and vote. However, the nature of the issuer, so whether or not the issuer is private or public, has an impact on the frequency of the words disclose, conflict, and reporting. So quite interestingly, we find that public bodies focus more on public disclosure and reporting requirements, which perhaps is not really surprising. So the findings suggest that the nature of the issuer is the key variable with most impact, probably because public issuers are more likely to copy the already established UK model. Also, another interesting finding is that the word monitor is more often used in codes that have a mandatory element, whereas escalation is found more often in codes that are only available in English, possibly because escalation is an English term which is less commonly used than the other words. So maybe for non-native speakers, non-native speakers may tend to avoid the use of that word. It is also noteworthy that the categories about the nature of the code, the legal families, and the global financial center are insignificant. So to phrase it in a more positive way, it cannot be said that the diffusion of stewardship is obstructed by the civil common law divide. And we have also seen that in the networks. So next, we calculated the overall similarity of the codes that were published after the 2012 code. So the 21 subsequent codes to the UK 2012 code. And you can see here that the EFAMA code, but also the ECGI code, appear to be quite similar to the UK 2012 code. Whereas if you go at the bottom of the table, you can see that, for instance, the Swiss code or the Dutch code appear to be less similar to the UK code. So this is a confirmation of the network analysis. And you can see that most of the outliers of the network analysis are also quite at the bottom of this table. I think the only, perhaps one finding that I need to highlight, and that's quite interesting, is the Danish code here. If you look at the Danish code and compare this table with the network analysis, in terms of language, the Danish code is not really close to the UK code. So they don't really use the same words, the same language. But if you look at the principles themselves and the content, then the Danish principles mirror those in the UK codes. So in other words, this is an example where the language may be different, but still the content is the same. So just to summarize the main findings of this paper and being conscious of the time, first of all, what we found is that even though there is some overall formal diffusion, especially in Asia among former British colonies, stewardship has traveled in non-linear ways and has often been adapted to local contexts. For instance, Japan has adopted a much more milder version of the UK 2012 code. The second key finding is that even though diffusion processes are too varied and too complex to be reduced to a direct one-way transfer, among the 7 key stewardship principles of the UK code, we found that the principles on escalating engagement and the principles on collective action are the ones that traveled the least. And this also confirms that UK originated norms have been renegotiated at the local context. So in other words, even when codes are drafted in a similar way to UK standards, as for instance, in the case of Malaysia or Singapore, they do so sometimes on a superficial level, often omitting key UK stewardship principles. And the Malaysian example is key here, because in terms of language, the Malaysian code is very similar to the UK code, but the Malaysian code omits certain principles. The third finding is that there is no strong legal family effect on the diffusion patterns. So while we find support for the diffusion of the UK stewardship model to common law countries in Asia, as Mathias explained, we also find evidence of diffusion in other places and in other ways. So for instance, diffusion from the UK to Denmark or Japan, diffusion between EFAMA and Italy, or between ICGN and Kenya, but also some regional clusters in Asia, for instance, the one between Japan and Korea. So to sum up, the paper covers significant ground and is the first to examine with a method of content analysis the diffusion of stewardship norms. We saw that stewardship has traveled across many jurisdictions with various legal systems, different markets, different cultures. But if there is one thing that the paper has taught us is to keep an open mind. And when we started writing this paper with Mathias in 2019, we never anticipated how complex the diffusion patterns would have ever been. So as we're approaching the end of the event, I would like to close this presentation highlighting some possible future directions. So from our work, it is becoming clear that stewardship means different things for different companies and different investors. And future research could possibly follow this insight. For instance, stewardship today has many varieties, both in terms of concept, but also in terms of practice. From a conceptual perspective, stewardship today is not only about shareholder monitoring. It's not only about incentivizing investors to become actively engaged stewards. Rather, stewardship today is moving towards responsible investment and ESG integration. And the latest UK 2020 code, for instance, recognizes investors as guardians of market integrity. At the same time, not all investors practice stewardship in the same way. For instance, large asset managers, including index funds, exercise stewardship at the level of industries or markets, while activist investors exercise stewardship at the level of individual companies. So future research should therefore analyze the practice of stewardship at the firm level and examine, among others, how differences in ownership structures across countries impact the application of the stewardship codes. Also, probably because the UK code is so different and the UK 2020 code introduced an expansive notion of stewardship, it is also conceivable that future research may want to track a possible second round of exportation, this time of the revised 2020 model. So thus, while the future of stewardship is not perfectly predictable, and diffusion involves various actors, various contexts, and complex pathways, it is likely that stewardship norms and practices will continue to travel globally. But perhaps diffusion will be through different means, and perhaps stewardship may travel through corporate governance codes, or in Europe through the transposed amended Shareholder Rights Directive, or perhaps through sustainability reports, confirming that the UK may serve as an exporter, but not as the only good corporate governance club. Thank you for your attention. I'm sorry about the internet problems, and do not forget to check our Global Shareholder Stewardship website for updates and future work. Thank you.
Yep. Thank you, Dionysia. I don't think I should repeat what I said in the introduction about the importance of your work. People mention ESG issues and the pivotal role that institutional investors should play in, essentially engaging in stewardship, not only of companies but also, of the planet, literally speaking. So I believe that people will look at your work and indeed draw inspiration. The legal part of the working paper and law part is coming to a close. Marco, would you like to say some closing remark?
Sure. So thank you to all the participants for three excellent papers. Now, of course, the last one, I can't resist, apart from the do not waste a good crisis. Imitation is, of course, the most sincerest form of flattery. So that's something that we saw. Now, the interesting thing is, of course, who didn't flatter the UK by not having a stewardship code, but maybe that we can debate on another occasion. Now, the two papers I thought actually were quite linked, because they do show that legal scholars now use technology to actually analyze texts, which is natural. I mean, since lawyers do write texts, it kind of seems obvious, but I think we're going to see, that's a personal prediction, many more new insights from this as we move along. Clearly this is something where we can get insights, and maybe when technology proceeds, we will really be analyzing, like linguists have for legal for languages, for language families, also for legal families, have much more granular research on all of this. So that was, I thought, a great way to close the day. And Let me just close by finishing. Well, first of all, remind you that ECGI is a public good producer. We bring research, leading research to the world, hopefully with impact. I thought we saw three great examples of that today. Now, we couldn't be doing what we are doing by not charging people without sponsors. So let me just thank again the sponsors. So first of all, the Wallenberg Foundation, who have kindly lent their name to our lecture. And of course, the sponsors of the Working Paper Prizes, Cleary, Gottlieb, and this year, the European Corporate Governance Foundation, and more generally, the donors to the ECGIF, namely Investor, AstraZeneca, and BlackRock. And for those of you who attended the ECGI AGM earlier today, we are going to launch a major fundraising drive this year, very ambitious, to essentially double the balance sheet. So if you have any friends who wish to donate to good causes, Elu is the man. He is the receptacle for all these donations. Yeah, do send the checks or Bitcoin or whatever you have to the foundation. Now, I should also mention Norges Bank Investment Management, because they have sponsored an important COVID workshop for us this year. So we have, and of course, the institutional members and academic institutions that have joined ECGI as members and supporters. And that's colleagues who've actually signed up their own institutions and often do that through their own research budgets in order to enable us to do what we do, including what we've done today. Now, last thanks go, of course, to the people who bring it all to you and communicate and actually produce these working papers. So Vanessa Paget, who is online, and Noreen, they tweet and LinkedIn and do little videos of your working papers that reach all kinds of generation. Even one of my kids have looked at one of the videos, not one of mine papers. I shall not reveal which paper it was. And of course, Una, who produces the working papers, Suzanne, who sends out the invoices, and of course, Elaine, who keeps it all together. Because without her, we wouldn't be here, basically. So thank you again to all of you for attending, and have a very nice evening in Europe and a nice afternoon in the US, and sleep well in Asia. And I hope and I look forward to seeing you all again in person, but online also has its charms. Thank you very much.